Good evening, distinguished guests, professors, colleagues, and my dear friends. A very warm welcome to the official launch of the book WTO and Digital Trade, jointly organized by the Center for WTO Studies as part of the Center for Research on International Trade, IIFT, and Dharamshastra National Law University, DNLU, Jabalpur. We have two limbs for the program this evening. The first is a panel discussion, which will be followed by a high tea break at around 6:15 p.m. At 6:45, we will resume to officially launch the book. I invite you all to kindly relax and enjoy the discussions. Digital trade has become central to the global economy, encompassing cross-border data flows, e-commerce, digital services, and regulatory standards. All of these shape market access in numerous ways. Its rapid growth also raises complex questions around privacy, cybersecurity, competition, and inclusion, making it essential for policymakers, lawyers, and industry stakeholders to engage in dialogue. Such discussions ensure that evolving frameworks balance innovation and openness with fairness, security, and sustainable development. This book attempts to take on this very challenge. Today's event marks the formal launch of the book WTO and Digital Trade. It provides a platform for distinguished policymakers, academics, and practitioners to reflect on the WTO's evolving role in the digital era. The discussions will highlight challenges such as regulatory adaptability, balancing innovation with protection, and strengthening international cooperation in digital trade. To put together this collection, the team had sent out a public call for papers, which received an overwhelming response. They received contributions from people with different levels of experience from within and outside of India. The final product that you see before you has 18 chapters that has now followed blind peer review. The book WTO and Digital Trade explores the intersection of international trade law and the digital economy. It critically examines whether the WTO's existing frameworks adequately address these issues that I just mentioned, such as cross-border data flows, digitally delivered services, AI, intellectual property issues, and anti-dumping in the digital space. Moreover, the book contributes fresh insights for all of these interested parties at a crucial juncture in the global economic governance regime. Before I hand it over briefly to Mr. Mishra to then introduce the book to you, let me quickly bring to light the different members of the editorial team behind the book. The book was, of course, published by the renowned publishing house Bloomsbury. The chief editors for the book are Dr. Preetam Banerjee and Mr. Utkarsh Mishra. They were supported by managing editors Dr. Amit Randev and Ms. Monica from the Center for WTO Studies, and assistant editors Abhay Gupta and Saurav Tiwari from DNLU, Dharamshastra National Law University. The foreword was graciously penned by Dr. Anup Vadhavan, who was the former Commerce Secretary of India. It was backed by a formidable editorial advisory board comprising Professor Dr. Manoj Kumar Sinha, Dr. Arpita Mukherjee, Mr. Deepak Maheshwari, and Dr. Professor Murli Kallumal. This book, of course, is a humble attempt to open up an academic engagement and reignite the discussion on the subject matter. So to share more about the editorial vision and structure of this book, may I please invite Mr. Utkarsh Mishra, Director of the Center for Studies in International Trade and Investment Law and Assistant Professor of Law, DNLU, to join us. Please join me in welcoming Mr. Mishra.
Thank you so much for this introduction and for such a warm welcome of our entire team from Jabalpur. And I'm highly indebted to Professor Dr. Preetam Banerjee and his entire team for setting this up. And this is such a brilliant occasion because often the confluence of industry and academia is frowned upon. And the results of an outcome of an academic inquiry like this is questioned. Last evening, I was having a conversation with my team member Abhay from the Center for Trade and Investment Law, and Abhay asked me a question as to whether what is the immediate outcome of such an academic inquiry, and what do we intend to do with this book, and what do we intend to do with this sort of knowledge production that we have done in this entire process. I mean, I cannot have an immediate answer to such a question, but the larger and the most important significant part of this entire exercise is to raise questions. And because nothing can have an immediate outcome in very short run, and it does have a very longer impact. With this idea, we conceptualized this book with Dr. Preetam Banerjee sir, Professor Manoj Kumar Sinha, my Vice Chancellor, and Dr. Amit, who was my partner in crime in this entire process. And we did this in Delhi and in Jabalpur. So the role of Asian cities in developing such kind of literatures is also relevant. And once we conceptualized this idea, we also thought that we will not limit it to only established scholars in the domain and let the invisible voices become visible. Because often in such kind of literature and academic books, what is seen is that we often celebrate romanticize rather the celebrity status of some established scholars, and we depend on their opinions rather than, instead of also listening to the voices of students, researchers, practitioners who are deeply concerned with what digital trade means. And this is where we intend to bridge the gap between industry and academia. Somewhere we can connect common people who are doing academic research, who are interested in digital trade, who are concerned in this area, and they want to take their opinion to the policymakers, to the government, to see what all issues are arising in this domain and to actually analyze how is it impacting them in reality. So we have papers on intellectual property rights, from cyber security to cyber governance and digital localization, so many issues which possibly could not have been covered in any regular symposium of sorts. So this book comes with that bunch of knowledge production that we have tried to create under the guidance of Dr. Preetam Banerjee sir and my Vice Chancellor, Professor Manoj Kumar Sinha. Curating an edited book must be an inclusive process, and this is the running soul behind this entire process. And that's why we allowed people from the common public in the form of their, in their capacity as students, as scholars, as practitioners to submit papers. We received around 70 papers, which was a good deal to, first of all, receive in such a initiative, because not everybody might be really concerned about digital trade, but still we received these many papers. And the entire journey of curating this book was guided by some immense personalities, with people like Professor Abhijit Das, who is sitting in the front row, because he was also present in Jabalpur few months back when we had a trade remedies course for our institution. And the insights that Professor Das gave on digital trade were quite instrumental in shaping the entire structure of the book. Professor Murli Kallumal sir, Deepak Maheshwari ji, I did not have a direct interaction with you, sir, but possibly via your email and via your concept note, I could gather your intention as to what you are trying to convey. And we had tried to select papers according to that policy orientation and academic orientation. Preetam Banerjee sir, of course, even though he was in Delhi and he traveled to Jabalpur for that trade remedies course, but his smallest of his insights in this book have been key source of shaping this entire book into a final product. My Vice Chancellor, Professor Manoj Kumar Sinha, my mentor, Dr. Gargi Chakrabarti, who is an IPR expert, and she has also submitted a chapter in this, but she also gave me insights as to how we can creatively create such kind of a book. So we received the submissions, and we basically evaluated the submissions in two-stage process, which was primarily a peer review process in which We did a technical round of review and then a content review. The content review was excellently done by the team of Center for WTO Studies, consisting of Dr. Amit and Ms. Monica. The technical review was done by the team of DNLU, Abhay and Saurav. And finally, copy editing, finalization of manuscript took almost a month. And my team from CITIL, they established communication with the scholars, sought several revisions from the contributors, and we were able to finalize the chapters in the end. I just don't want to talk much about digital trade conceptually, because we have some very renowned people, people who have done good work in that area, who will be talking on the intellectual part of the book. But I just want to mention one thing, that this book does not sum up the entire discussions on digital trade. It rather is just a beginning of a new journey. And it is just raising few pertinent questions which might be relevant for the entire policy-making process. So that's the whole idea of this book, that in such a complex world of international trade, where digitization and e-commerce, and very recently WTO released the report on AI and trade, how can they be made to work together? How can we also make it an entirely inclusive process in terms of a stakeholder consultation? Because we often forget that a stakeholder consultation is not just about getting comments and suggestions from people and only traders, importers, and exporters as to how it is directly impacting them. People who come from academia, people who come from research background are also an equal stakeholder in industrial policy making. And this is also the essence of this project. I thank Professor Dr. Preetham Banerjee for doing this project under his wings, and for doing it under the aegis of Center for WTO Studies. Thank you so much, sir. And Amit, hi, and thank you so much for setting up this entire event in such a brilliant manner. Thank you so much. Thank you.
Thank you for these insights, Mr. Mishra. This was such a refreshing take and an incredibly uniquely designed endeavor, and I truly hope that the success it deserves is merited to this book. We will now move to the panel discussion on this book. It's my honor to briefly introduce our eminent panelists who are here with us this evening. The discussion this evening is moderated by Dr. Preetham Banerjee. The esteemed panelists for this evening are Professor Abhijit Das, Professor Dr. Murli Kallumal, Professor Dr. James Nedumpara, Shri Deepak Maheshwari ji, and Dr. Gargi Chakrabarti. I'll now introduce each of these panelists and request you to please join us and take your seats here following your respective introductions. Professor Abhijit Das is the former head of the Center for WTO Studies and has almost 2 decades of experience in international trade. He has participated directly in many multilateral and bilateral trade negotiations and has worked in the UNCTAD India program during 2005 to 2010. Professor Das has also recently published his book, Strategies in GATT and WTO Negotiations, with the Oxford University Press earlier this year, and it has received much acclaim. It is, of course, an honor to have you with us this evening, sir. Please approach the stage. Professor Dr. Murli Kallumal is a professor at the Center for WTO Studies and the head of administration at the Center for Research on International Trade. He has over 25 years of experience in trade and development, has represented India in regional trade agreement negotiations, and advises on non-tariff measures issues and market access issues. He was also responsible for conceptualizing and creating 2 web-based databases since the year 2003 on non-tariff measures like SPS and TBT. Thank you for joining us this evening, sir. Please join us. Professor Dr. James Nedumpara is the professor and head at the Center for Trade and Investment Law. He advises the government on trade and investment matters and is a widely published authority on international economic law, including his paper on digital service taxes for the reputed Trade Law and Development Journal. He has also been a part of the Indian delegation in disputes before the WTO. We're really grateful to have you, sir. Please join us up. Shri Deepak Maheshwari ji is Senior Policy Advisor at the Center for Social and Economic Progress. He has decades of experience in technology policy with global companies and has played a key role in shaping India's digital policy ecosystem. He has supported the Department of Telecommunications during India's G20 presidency. He's also just recently published his policy brief, Digital Inclusion, Policy Pathways for Public-Private Partnerships, with the Center for International Governance Innovation in Canada. We're indeed fortunate to have someone with this level of expertise amidst us this evening, so it would be lovely to have you up here, sir. The last panelist for this evening is Dr. Gargi Chakrabarti. She's the assistant, sorry, my mistake. She's an associate professor of law and the dean of faculty at Dharamshastra National Law University, Jabalpur. She specializes in intellectual property law with international research experience at the Max Planck Institute of Innovation and Competition. She has over 15 years of teaching experience and contributes actively to the World Intellectual Property Organization's Academy as a tutor and has done so for the last 6 years. We're really keen to hear your insights on these issues that are incredibly topical. So please join us up on stage. And finally, to moderate the discussion, I am delighted to hand this over to the co-editor of this book, Dr. Preetham Banerjee, head and professor at the Center for WTO Studies. Dr. Banerjee has extensively published on issues related to international trade, regional integration, regulatory reforms, logistics and connectivity, and trade facilitation. This is following his extensive, rich experience working in national and international organizations. Dr. Banerjee has also recently, that is earlier this year, co-authored a working paper, Negotiating for Digitally Delivered Services, Framework for a Comprehensive Approach. So, of course, we're keen to know what you have to say about all of this, sir. Please join us up.
So, thank you so much, Kamya, for that wonderful introduction to all the panelists, and a very warm welcome to all of you. This is a very interesting topic, and I'm going to dive straight into it for the simple reason that we have now less than an hour as per our schedule. So instead of giving my own views, I'll straight away go to our panelists who have very rich experience in each of these issues. But just to take 10 seconds, as was mentioned by both Professor Utkarsh and by Kamya, the book covers a wide range of issues related to digital trade. It goes into aspects of market access, issues of discrimination for foreign suppliers of such services and goods. It looks at the linkages with environment and sustainability. It looks into issues of equity, a view from the south, and a range of other areas. And we are very blessed to have panelists who will be able to do justice to this wide range of topics that we have. So I would like to start with Professor James Nedumpara. My first question to you, by the way, before we start, what we will do is we'll have a first round of opening questions to all the panelists, and then we'll hold you to about 5-6 minutes maximum for the first round of comments, and then have a last round where we can have closing remarks from each one of you. So, Dr. James, my question to you is that, do you think that the issue of non-discrimination as it applies to digital trade, namely market access and national treatment, are adequately addressed in the existing GATT and GATT's framework? And if they are not, how do you think resolution can happen? Do you think we need new agreements, or are there other pathways towards this? Thank you.
So thank you, Preetham, for this opportunity. I wasn't keeping very well, but I still wanted to be part of this initiative. This is actually a wonderful thing, and editing a book is always a tough thing. So my own feeling is that this is fairly complicated. If you really look at the WTO framework, especially the services framework, the commitments are actually in the name of positivist. So to an extent, the commitments will basically determine whether discrimination is taken care of there or not. But to my knowledge, I think you have to really look at the 1995 document. In the 1995 GATS, India has taken only 33 commitments. So that is actually a very shallow kind of commitment. But if you really look at some of the recent free trade agreements, this issue has been tackled in a much more bigger way. So it all depends. I mean, I can't actually give an answer whether it has been tackled appropriately or not, but to an extent, the GATS framework provides an answer. And in free trade agreement, I think it is a bit more holistically covered. So that is actually a very preliminary kind of an observation. Then we have to also look at some of the recent agreements, the CPTPP agreement for that matter. Then we have to look at the USMCA agreement. In some of these agreements, you actually get a bigger, some more ambitious commitments. But when you really look at the joint statements, what the United States has agreed to with other countries in recent times, some of these flexibilities are actually being taken away. Look at the Indonesia agreement. These are actually bad trends. So my own feeling is that it all depends on the situation, but the flexibilities are slowly being taken away by these kind of joint initiatives. So these are my preliminary views on this particular matter.
So that was quite brief and efficient, and those are very interesting opening remarks. In fact, we will probably go a little bit deeper into these issues because, as you rightly mentioned, that we have the international regime perhaps being driven by bilateral or mega regional agreements like CPTPP, and the implications of that are important for us to look into. A related question to Professor Abhijit Das, if I may turn to you, sir, is that do you think that WTO is an appropriate forum for developing rules for digital trade, or do you think there are already existing multilateral frameworks that actually address many of these issues, and the resolution can be perhaps found under those multilateral frameworks? The ITU, for example, comes to mind. Or do we need to create an entirely new framework for digital trade because it is so radically different from the old 20th century analog trade that we were used to? And in your opinion, to what extent the JSI has been able to perhaps do that in that sense? Thank you.
Thank you, Dr. Preetham Banerjee. At the outset, let me compliment the editors and the entire team responsible for this wonderful book, as well as the chapter authors. Dr. Preetham, turning to your very interesting question, let's bear one thing in mind, that the rules of GATT evolved based on the experience of manufacturing over at least 2 centuries. There was no significant change in the manufacturing or the process of manufacturing or experience of different countries in manufacturing for almost 200 years. That is not the case with digital. Digital is something we are seeing in its incipient stage. And given the current stage of development of digital economy, we really do not know in which direction this will move, what flexibilities countries will require, either for policy perspectives with the objective of, let's say, enhancing their economic prowess or for protecting consumers. So my limited submission on this issue is that for countries that are at the forefront of digital technology And let me say very clearly, India is not one of those countries. We are at the forefront of delivering services around digital economy, but we are not yet there when it comes to creating digital products. So it is not in our interest to have multilateral rules or even bilateral rules on digital issues. That will only constrain our hands. That will prevent us from fully leveraging the opportunities which digital economy will create. Those opportunities, otherwise, if we go by what is happening around digital rules in the Joint Statement Initiative or in various FTAs, if you look at those rules pursue 3 or 4 objectives. First objective is digital players do not want to pay taxes. Second objective is digital players world over believe in deregulation. So much of what is contained in many of these provisions in the digital chapters is actually tying the hands of governments from regulating the digital players. And third, of course, is tying the hands of governments from implementing policies to catch up with those who are at the frontier of digital technology. So to my mind, at this juncture, for a country like India, it is absolutely not in its interest to participate in rule-making at the international level, be it through JSIs, be it through multilateral initiatives at the WTO or in FTAs. At this juncture, countries like India should prefer to tackle issues around digital through their domestic rulemaking. And there, the most important thing is competition. We do not, at this juncture, need international cooperation on it. We must have strong domestic rules to address competition, anti-competitive practices in the digital sector. So I'm going to stop at that. But let me once again compliment Dr. Pritam Banerjee, Mr. Utkarsh Mishra, Amit, Monica, Saurabh, Abhay, and the entire team for having brought out a wonderful book. Thank you.
So thank you for that. I think those, again, are very interesting initial remarks. We'll come back to you because we have seen, in the last couple of weeks, in fact, some very interesting developments. We have the proposed HIRE Hire Act, which has been proposed in the US Senate, and of course, that has raised certain eyebrows. So we will come back to this topic of, how we are going to frame these rules. But if I may now turn to Professor Murli Kallumal, my colleague from the center, my question to you is that while facilitating digital trade is essential for its growth, concerns remain about widening the widening digital divide that we are seeing, and also the economic consequences of that. So, do you see a fundamental conflict, in terms of the innovation and the new product development that we are seeing at the rapid pace globally on digital products and services, and rising inequities that come from it? What are your views on that?
Yeah, thank you. Let me first of all thank Professor Pritam for asking me this question. Drawing from Professor Abhijit Das, let me expand on that. I will point out at 3 points which is globally happening in terms of the digital trade. Of course, I am a person who works on goods, and I've been working all my life on goods. So Professor Das actually asked me to work on 114. If you remember working document 114, there are 34 products in that in HS terms. So when I started tracing its evolution, in terms of trade movement, between countries, so I categorized them into developed to developed, developed to developing, and LDCs integrated into the trade. So I found some clear demarcation. 1998, 2008, these 2 periods were quite remarkable in terms of the kinks which was observed in the physical trade. So thereafter, I then traced to bring in the digital trade aspects with respect to the digital products. Very clear trend was observed in digital trade between developed to developed but very clearly falling from 1998. Thereafter, developed to developing fell from 2008. So very clearly there is a digital divide existing at the global level in terms of the capturing of the data. So when we capture the data, you will observe that there is this globalization phase around somewhere around 2012, 13, the rising, and then somewhere around 2020 it is globally the export-import data is actually plateauing out. So what one can say is, since I'm an academician and I work on data, this is also because of the lack of reporting of countries. There are errors because of that also. But otherwise, when you capture the mirror data, there is a clear digital divide. And to the solution part, I'll come in the next intervention, which is.
So, thank you, Professor Murli Kallumal. That was, I think, the initial remarks are interesting enough, but there are, follow-up questions that arise from this, because many people would argue that some of the innovations are, productivity enhancing, or in some cases they are democratizing access to knowledge, and therefore they, in some ways, also perhaps, address equity issues to a certain extent. So, but we'll come back to that point subsequently. I will now turn to Professor Gargi. Ma'am, what reforms you think are needed in WTO's trade law frameworks to accommodate AI-driven innovations in intellectual property disputes?
We have already started that particular controversy or discussion, the AI-generated, AI-driven. So pros and cons, we know that. The thing is like that, there is we need to know what is what. So that is why, I think everyone is struggling at the very moment what could be, because we know that policy formation, EU is having their own act. So intellectual property rights also somehow come into the questions. So in this manner, if WTO is giving that particular guideline as well, so it could be better for all the countries to how we are going to deal with, or in what manner we are going to deal with. Could be a pathway in this way. The thing is like that. Now, because somehow, though it is not actually AI generated, the program in such a manner that it seems like that machine is only doing that particular job. Actually, it's a program based. So the e-commerce and how the social media platform even doing the trade, so the gathering the data, sir also mentioned that big data and anti-competition issue. So all this together comprehensively through the brainstorming, we can have a very good manner one policy document which can guide the future.
Thank you so much, ma'am. That was, I think, again, very initial remarks, because there are several issues that we would like to explore further when we take forward this conversation. Now I'll turn to Mr. Deepak Maheshwari. We have a more philosophical, fundamental question for you, sir. And the debate that we have also seen in the text of the, across various chapters, seems to be that there is at least on the face of it, a conflict between, a nation state's need to maintain digital sovereignty, address issues of national security, at the same time keep the market for digital goods and services open, because there are opportunities and economic benefits that are flowing from that. How do you see this inherent, first of all, is there an inherent contradiction? And secondly, how do you think we can move towards resolving some of these contradictions?
Okay, so before we come to this, I think it's important for us to realize one important aspect. That is, it was because of digitalization to a great extent, the trade in services just won't have been possible to the way it has grown and the way it is growing, but for digitalization. And to that extent, if we start creating these type of walls around us, these walls are, I mean, we believe that we are creating actually walls, which is, okay, we are allowing the data one-way flow, but the fact is that these are not walls in physical terms, but they'll actually become walls. And the moment you create these walls, not only the data flows will be impacted in one way, they'll also be impacted the other way. The second is, we should also look at the definition of digital trade itself. Now, from a definition perspective, of course, there are different definitions from different places, and over the decades they have been evolving. But I found this definition very interesting, which is very short, very crisp, but at the same time extremely broad, which is by OECD, WTO, IMF, and this was in 2023 only, which is anything which is digitally ordered or delivered is digital trade. Now, looking from that perspective, if you look at hospitality, you look at tourism, a great amount of all of this is digital trade. Now, the moment we are talking about this type of, let's say, digital sovereignty, the way people are talking these days, I think to a great extent, if we do that way, what will happen to all the international travel, all the international tourism, etc. So I think we also need to have a wider outlook on these issues rather than looking only within the realm of what is digital products or digital services per se, that is IT services or software or entertainment, which might be happening that way. I mean, today, for example, books, even this book, for example, of course, there's a physical copy, but I hope and guess that there'll be also a digital copy. And obviously, we would like this digital copy to be available not only in India, but also all over the world. So now how does it travel? It travels only through the digital means. So from that perspective, if you see, I'm not saying that people should not be bothered about the data flows. People should not be looking at the type of controls that they can and should have about the flows of certain products and certain data flows. But those should be more narrower, number one. Obviously, there are things which are related to national security, etc. Obviously, one has to look at those things in a different perspective. And also, the way the experience has happened in the past 30 years, ever since the WTO came into being. And I think the black swan moment was not that time. It happened 6 years later with the entry of China in WTO. And because of that, suddenly their market share, especially in the digital products, suddenly from 2%, it went up to 14% by 2011, and today I guess it might be more than 25%, maybe even higher. And although now we have, through PLI, etc., many things which are happening in India in terms of products, but still the net value addition, obviously, in India is much smaller compared to China. So I would say when we are looking at this, it's not so much of a conflict, I would say, or an inherent conflict, but I think we need to see that these things will continue to stay together. Few things we do need to control, but I don't think we need to go overboard about controlling these things. Thank you.
Thank you, Mr. Maheshwari sir. I'm just trying to be mindful of the time because both Amit and Monica have been very strict on that count with me. So we are actually doing very well. We are at 5:35, so we have a half an hour left. So what I'll do is, because now we have heard from all our panelists and they've all touched upon very key issues. Let me take a couple of minutes to put these strands together and then go to the next round. So the broad debate, I think, on digital trade today is around 4 or 5 aspects. The first aspect obviously is related to the rights of businesses, including foreign participants in this business. Over there, as we heard from both Dr. James and Professor Das, there are concerns in terms of national regulators being able to control or manage this business in a manner that maintains the sovereign rights of countries, but at the same time, as was mentioned by Mr. Maheshwari, this openness has economic benefits, including for India. The provocative question I would have for all my panelists is that the divide between products and services is increasingly blurred, and the integration levels are very high. I mean, look at Tesla as a car. It's, you know, it's an EV. People call it a glorified smartphone on wheels. And a lot of the money that you are paying for is really the data services that go into that vehicle. A lot of that is managed back end by GCCs here in India, so there's obviously an India link. So, you know, where does one start, one end? That's one fundamental question. And in that context, we have seen recently this proposal of a so-called Hire Act, which brings in a 25% duty on all offshore outsourced services from the United States. We know services are delivered on 4 modes. So-called mode 1, on which this duty is being put, is all mostly digital today. And it is really one of the strongest elements of India's rise as a services exporter. That brings us to the question very clearly that there was at one point of time some level of comfort that Mr. Trump obviously has completely destroyed, that existing commitments in this case GATS will not be touched upon, and therefore even if there were no other disciplines or other frameworks to, you know, ensure or create predictable market access rights, GATS already does that. So we don't need anything else beyond GATS. Obviously that violation has asked new questions. Of course, it asks the fundamental questions: what is the value of a trade agreement in the first place? But that's an important debate to touch on. The second issue is largely on terms of protecting both your consumers and your citizens. So when we talk about data flows, there's an element of ensuring that data that flow out of your country, or whoever has access to your data, does so in a manner that is not inimical to the citizens' individual interest. There are also consumer protection interests. An extension of that, obviously, is the whole issue of competitive rights, competition, you know, the digital giants not, you know, completely gaming the market in a manner that we as consumers lose out. That, of course, leads us to the discussion that we were having with Professor Kallumal on equity issues. Do the development of these products, these services, these platforms lead to inequitable outcomes overall? You know, I heard a very interesting speech by a trade union leader who will go unnamed here, who talked about the fact that, you know, the Swiggies and Zomatos of the world have actually created a massive dissonance in terms of labor rights. So even that is an equity-related discussion. And then that goes back, I think, to the issues of also, you know, the rights of people who are doing the innovation around this whole space, and what defines innovation in this space. You know, and again, there is, in my mind, and, you know, and I'm an economist, madam, so I don't think like a lawyer sometimes, so pardon me, but I look at it as a value chain of innovation. So where does the, you know, the person sitting in an office in Hyderabad or, you know, or Mumbai, who is doing a lot of the algorithm work, you know, where does that person's rights come in when the product is developed? Right? You know, what ensures that this fair share of the value chain is also going to the people who are working on this value chain, which is much more difficult to define than, let's say, the traditional research and development activity. So, you know, I have raised a broad spectrum of issues, and perhaps we can go in the opposite order this time and start with you, Dr. Gargi.
I mean, it's pretty easy to handle. At the same time, it is very hard to handle. Now, the understanding is not really different from the physical world to the digital space. So the thing is like that, in case of India, I mean, I'm just pointing out the problem is, in case of intellectual property rights, we are not very clear as such. Why? Because whenever you are entering into any office or any university even, you're going to have this much papers to sign. What are the clauses there for the IP? But here, it's not as such very demarcated what is going to the employer, what is going to the employee, what could be the profit sharing. All these nitty-gritties are not clearly mentioned even for the physical world. So we need to implement that first. So the controversy between that computer program per se is not patentable. It is there, it will be there. So it's a criteria-based subject matter. We are going to judge based on the criteria. So the software, whenever is having the technical effects, then only going to get the patent. So that's there. But the first and foremost thing, that clarity, who is going to hold the economic rights, who is going to hold the inventorship or authorship. Yesterday only Utkarsh asked me regarding this book publication. Ki different publisher is giving the different way that particular thing. I mean, it's a regular. So you you have to talk with me what exactly the regular practice. So if we can somehow clarify this from the startup, small entity, medium entity, large entity, if we have that clarity, then we can recognize the innovation. And recognition is not always the economic recognition. It's a both. Non-economic recognition and economic recognition both. So whenever any innovation is recognized by someone else's name, as such not getting money, that is also a proud moment for that, getting that particular credit. Yes, I am behind that particular innovation. So that non-economic part is as well as important, and also as an incentive if the person is getting some economic benefit. So all these things, we are somehow really behind that. With that, just I want to add another thing which we are lagging. That is the non-disclosure agreement from the IP point of view. So when you are allowed to disclose it and when you are not allowed to disclose it. If it is a sensitive data, where is the line, fine line, and you are not allowed to cross that particular thing. Socio-culturally, we are different from the good lot of countries. So the thing is like that, this sort of with the modernization, we need to develop this concept as well. Otherwise, dealing IP and digital trade, that particular combination could be difficult. So that's the point of mine.
No, thank you, Dr. Gagi. I think that actually did explain it very, very clearly, and it puts on the table some very interesting points that we need to take further. Can I talk to you, can I turn to you, Mr. Maheshwari, and ask you to come back again on that, what we were discussing and what you mentioned in your initial remarks. And how do we reconcile this whole issue of rights, market access, business development, as well with the sovereign rights, regulation, policy space?
So I think as far as rights are concerned, one very interesting thing that we have seen, at least in India, is this whole equalization levy, for example. So that was one way for India to actually garner a certain amount of taxation revenue from the economic activities being carried by multinational companies in India, which earlier India was being deprived of. So there are ways and means in which within the national jurisdictions, using the domestic policies, one can exert. Second thing is, of course, in terms of the market size itself. So when we are looking at market access issues, obviously, depending on the type of market that we have, there are a whole lot of companies as well as countries with whom we will have a certain level of leverage. But that leverage will not be only unidirectional. We'll have to give in something to get in something. It can't be only, okay, we take it all and we don't give in something. Because obviously, whether it's a trade negotiation or anything else, there'll be some give and take anyway. The third aspect, I just want to briefly touch about what Professor Chakraborty mentioned. So, for example, in the US, you do have a Bayh-Dole Act. And that's something which gives a very interesting framework for cooperation between academia, research, as well as the commercial organizations. And so, for example, a lot of people may not realize that Google's core algorithm, even today, the search algorithm, the page rank, that patent is actually held by University of Stanford, not by Google itself. So, because that was the scenario at that point of time, and of course, because of those type of things, those universities also keep on gaining a lot of economic corpus, not just the otherwise the reputational health. And the other aspect that she did mention, which is the non-monetary. So non-monetary, again, for example, even as an author, forget about as a patentee or as an inventor. In fact, recently, just about a month back, I read Rahul Matan's article where he said that authors write essentially to be read. And the whole concept of copyright came not because of authors, it came because of publishers. With due respect to all the publishers, I mean, they do a fantastic job as an intermediary between the authors and the readers. But the publishers and the printers, and because they are also making a certain investment, they are also taking a risk there. So the way things have to evolve, I would say that the risks as well as the benefits need to be apportioned to the amongst the stakeholders, and it should not be highly disproportionate. Thank you.
Thank you so much, Mr. Maheshwari. May I now turn to Professor Kallumal. We have some fundamental issues of equity, at the same time fundamental issues of opportunity, both arising from the expansion of this space in the digital economy. How do you see the regulatory space or the policy space evolving to manage this in a sustainable manner?
It's a very important question. Thank you, Professor Preetham, for asking that. See, when we look at trade, trade often gets captured from the port data. But when you talk about digital trade, it moves much beyond the ports. Okay, so where does the digital trade gets captured? It gets captured in the bank payment gateways. Fundamentally, it gets captured there. Are we accounting for that data to be brought into the mainstream assessment of the international trade? I suspect it is not being brought because there are no systems to integrate that data into the main systems. But of course, in India, we have a mechanism through UPI, United Payment Interface. I think students should work on this area. It's an interesting area. There is this movement of public sector data moving to private sector. There is that debate which is happening, and it is increasingly privatized. Data is getting privatized, and it's a privatized means profit motive. So profit motive mainly drives the capturing of data, and that fundamentally brings in the question of how equitable digital trade would be. The second aspect is, which I as a researcher feels, which has to be worked, because when you are operating in a three-country model, say, because all of the economists want to draw a simplistic model, because it's much more complex. The reality of the world is much more complex. Let us imagine there is a big market economy, and there is a financial haven country, and then there is an innovator. So these three countries, when they trade, the data between financial haven and the big market and the innovator and the financial haven does not get captured. So there is that complete absence of the data getting captured, and the policies around trade policies, which are increasingly being made, would be made with many assumptions being brought into the overall governance of the international architecture. So fundamentally, what we, as Professor Das also mentioned, GATT and WTO largely operated on goods. So physical movement of commodities. But the new era of digital trade takes us completely to an opaque and non-transparent data flows. So that has to be disciplined, and only a reform can do that. And I leave it to the future students to come out with solutions. So thank you.
Thank you so much, Professor Kallumal. So I'll come to Professor Das and then Professor James with 3 points, right, very quickly. So one, I think Professor Kallumal already touched upon this. One of the reasons why we have difficulties in taxation are the existence of these tax havens. And we have seen all of these digital giants, for lack of a better word, abuse the system. So that's the first challenge in terms of how do you tax some of these very intangible products. The second question that obviously comes is that we have such levels of innovation today, as we were discussing, where even perhaps the old classification system of services or goods are not adequate to manage what we are looking at. So to what extent are the existing trade agreements and structures will be able to handle that? And that brings us to the last point, that how stable or unstable do we see the cross-border trading rights and privileges that exist? And given the fact that this is an important area, at least in terms of employment and exports for India, what would your recommendation be? What should be India's policy going forward to balance, what Professor Das, you were mentioning, to retain some amount of policy space, which is obviously important, but at the same time ensure that our economic rise using on the back of digital opportunities is not stymied because of uncertainty. So perhaps Professor Das, you, and then Dr. James Yu. Thank you so much.
Thank you, Dr. Preetham Banerjee, for your question. Let me give very quick responses. On the issue of taxation, yes, there are challenges, but there have been innovative solutions as well. The way we levied the equalization levy, that was a good model. And having said that, that again reinforces the point which I mentioned earlier, that this is an evolving sector. Countries will have to experiment domestically before we should really talk of an international binding agreement in this area. And let's be very clear, the provisions that we are seeing in trade agreements on digital, you can trace almost each and every of those provisions to a document called Digital 2 which was the demands of the US big tech about just before the TPP negotiations commenced. So the trade agreements are actually an articulation of what the big tech wants. It is not an articulation of what a country like India wants. And let me compliment the editors of the book for including the chapter by Sofia Scacera, which very clearly brings out the difficulties, the problems, the risks, and immense pitfalls in getting into an international agreement in this area. And having said that, this is a very unstable situation. My very dark apprehension is that most developing countries, including India, have not yet realized the pitfalls of getting into a binding agreement in this sector. And we will end up, if not immediately over the next 4 or 5 years, almost conceding to most of the demands of big tech, which we certainly are likely to regret about a decade down the line, when the government will require policy space for regulating big tech, will require policy space for harnessing the economic opportunities. Unfortunately, those would have been constrained by the trade agreements. So Preetham, that is my elaborate answer to your pinpointed questions. Thank you.
Thank you, Professor Das. Dr. James, your views, please.
So thank you, Dr. Preetham. I think that is an excellent question. I think in the current world, when we really look at regulation on digital economy or digital trade for that matter, we are only looking at from a traditional trade perspective through goods and services. And I think maybe it is actually a good way to start off with, but it won't actually succeed in the long run. The plain reason is that digital economy will be the overwhelming economy in the future. So at the moment it may not be that big, but going forward digital economy will be the big economy. It will actually outsize the merchandise trade and the services trade for that matter. So you asked me the question about taxation, and I had actually the chance to work on the digital service tax matter. when we really look at this digital service tax, we know that the model of providing services or digital services has completely changed. If you look at the traditional method of income taxation, it is actually based upon a source principle. So that means the company will have to be present in a particular country. You need to have the nexus argument. And then we know that in modern times, that particular principle cannot actually exist. With respect to a large number of cloud services, where do you locate it? So that is why a different kind of a model has evolved, and we are actually looking at the market economy model, where sometimes the taxation will be based on a revenue principle and not based on a business income proposition for that matter. So this is a very simple area where I think the rules are actually changing a little bit. And again, my own feeling is that sometimes the taxation of the intangible economy will be a very important part of the future. And the current method of taxation, the individual method of taxation, starting from the 1913 US IRS taxation, will not actually hold true in the future. So that is why we need international taxation, I think, in discussions, and we need new models for that matter. And having seen the opposition to the Pillar 1 and Pillar 2 of the Base Erosion Profit Shifting Initiative, we imagine that it is going to be a very tough proposition. And if a country actually charges a DST like India had done in the past, India had to actually stop it, put a pause to it. What happened to France? There's severe opposition. Canada is actually facing retaliation for their own digital service taxation. So the point is that most of the, I think, the technology, the major dominant digital economies will protect their rights overseas. That is actually a given point of time. Absolutely true. So we are going to be in a very bitter world, bitter battle, in order to seize that sovereignty for that matter. And I read some of the papers here. They were talking about the traditional Westphalian sovereignty, where everything is actually within your own country. You have got the right to protect and preserve these kind of rights, including source code. But now that model will actually change. So that's why we had to be a bit more imaginative, and we had to also understand what will actually happen. But a couple of points I would like to mention at this point. One is basically in the extrapolation of the traditional methods of protection of individual rights, individual property rights, even in the digital economy. So when we think about the goods sector, the merchandise sector, or even the services sector, we know what should be protected. And that is why we have got the intellectual property rights, we have got the privacy laws, we have got the data protection laws. So the data is actually the conduit or basically the essence of digital economy. And it is anyway going to be a major property interest. It has got tremendous value as a property. In what form it should be allowed to go across the border. We can actually use some of these principles, but again, I think one argument I think which many people use is that the field is actually evolving. And that is a fact. But if you believe that, okay, this field is evolving, we are not actually ready for a regulation or for any disciplines internationally, we may be saving ourselves from the downside of it, but we won't be able to capture the upside of that particular economy. So that's why this is one area where I think some kind of a regulation may be extremely important, even in the short run, saying that it is an evolving sector, let us wait and watch how this economy will be, digital economy will be evolving in the future, may not be the right approach. But I'm not saying that I don't have the knowledge or the expertise to comment on these matters. But generally we believe that it is going to be a very difficult proposal. Only one last point which I want to mention. I know that there's a time limitation.
Please finish. We can extend by a couple of minutes.
Right. Or maybe just one point.
Yes.
I want to mention here. So you mentioned the issue of classification again. So the classification we have at the moment is a UNCPC classification of the 1991. That classification is completely outdated. When the digital economy, even the internet hadn't actually developed at that particular point of time. And my own feeling is that maybe a different sectoral classification will have to evolve in this field. That is why a huge amount of discussion will have to be there. Now when we look at the trade agreements, we negotiated an agreement with the UK in recent times, and there are negotiations. They're actually very small. You can say appendages to the trade agreement. That proposition will change in the future. So this is one sector. I agree with the Professor Abhijit Das that we have to really look at the domestic regulation. So domestic regulation is extremely important. Even in the European Union, they have got regulation. They're actually very good in the regulation. In India also we have done our own data protection laws. We also have a digital competition law for that matter. So we are also trying it out, but this is one area where I think enhanced efforts will be required to see that our regulations actually are on par with international standard. The problem here again is that, last point, we are actually going for a huge amount of fragmentation. If every country is going to have their own regulation, then we will reach at a stage where international regulation or discipline will be absolutely impossible. So this is one area again, when we start off, there has to be some kind of a common. I'll stop.
Thank you, Dr. James. So I'll quickly sum up because I think there's a couple of minutes of time still left. I think those were very interesting remarks. The three takeaways that I have that I want to share with the audience. First, obviously, as was mentioned by quite a few of the speakers, the domestic regulatory space and its development is critical. And I think we are a little ways behind. And it cuts across multiple areas, intellectual property, issues of market access, taxation, issues of rights, data protection, multiple number of areas. And that's why I think this publication is so timely, because this debate that this book encapsulates essentially is grist for the mill for young minds to come up perhaps with India specific solutions and provide them to the policy makers. And what we are seeing globally, and what Dr. James mentioned, yes, there is multiplicity, but there also seems to be basically three dominant schools of thought. So we have the so-called Brussels school, which is the European Union, which is, high on more control-based, more specific regulation. We have the, the Washington DC school, which, as Professor Das mentioned, is the outcome of the dirty 2 dozen, if not the dirty dozen. And then, which is obviously more laissez-faire, market-oriented. And then we have the Chinese school of thought, which even I have not figured out. I think I'll turn to my legal friends to help me explain what that school of thought stands for, but it is essentially a state-led system. So this seems to be where we are headed, and so challenges are going to be multiple. But I'll just end with one small 30-second experience, which I think will resonate with quite a few people sitting here. When I was growing up, I was born in the late 70s, so as a giveaway of my age. I saw the cities of Noida and Gurgaon and Pune and Chennai, and these suburbs grow and come up. And one of the critical reasons, the force behind it was India's, what I personally call India's first middle class revolution, fueled by the IT and IT enabled services. What is happening now with digital has the potential to do India's second middle class revolution, and it will be 10 to 15x that, given the breadth of activities it covers. So therefore, its importance to our future is immense, and therefore this book has immense importance in taking the debate forward. With those words, I'm very, very grateful to each and every one of my panelists. They're an expert, eminent experts in their fields, and I'm so, so grateful to all of you for giving us your time. I'm grateful to, of course, Professor Utkarsh, Amit, Monica, for the tremendous hard work they have done in coming up with these books, all the contributors, and of course everybody in the audience for sparing time and being here with us. We will be having a high tea just outside. Please join us for that. Thank you very much.
Before everyone proceeds to high tea, just wanted to thank all the panelists and the moderator for these incredible questions and such an insightful engagement. I think we're all going to be leaving this place a lot richer with all of this, so thank you for that. We will now, before proceeding to high tea, we will now first felicitate our guests of honor over here. So may I now request Mallika to felicitate Professor Abhijit Das. Harshita to felicitate Shri Deepak Maheshwari ji. Diksha to felicitate Dr. Gargi Chakraborty. Divyansh to felicitate Professor Dr. Murli Kalumal. Anmol to felicitate Dr. James Nidumpara. And finally, Anna to felicitate Dr. Professor Preetham Banerjee. Thank you all, everybody. Please join us for high tea outside. We will reconvene at around 6:40 before the session. Yes, so we'll reconvene here at 6:40. Thank you.